Mr. Chance,
Yes, I'm present. Good morning.
Dr. Kigaba,
Good morning. I'm present. Thank you.
Mr. Koza,
Thanks, Chair, present, and morning.
those are currently members all on the platform, Chair, and we may proceed in terms of the rules with the meeting, Chair. Chair, we're sharing the agenda, Chair.
Are we correct?
Chair, we're not corrected, but in terms of rules, we may proceed. We have more than 1/3 of the members on the platform, Chair.
How many?
We are 5 at the moment, Chair. But the rules allows us to proceed with the meeting, Chair. We have more than 1/3 of the members. Other members may still join us, Chair.
Okay. Can we then get a mover and seconder for the agenda?
I move, Chair.
Thank you, Member
I
Chance.
second, Chair.
Thank you very much. Yes, that's Member
Member
Webster.
Chazo Webster.
Thank you so much, Member Webster. Thank you
We'll
very
be
much.
joining Mr. Gama now, Chair, as well.
Sorry?
Mr. Gama has just joined the platform as well, so we do fully correct, Chair.
Oh, okay. Thank you very much. Are there any apologies, Andre?
Chair, we have an apology from Mr. Thring and Mr. Mdluli. Those are the only 2 I've received today, Chair.
Thank you very much. Who is leading the delegation from the DTIC?
Chair, we have the Deputy Minister, Mr. Limpi, on the platform, Chair, so he will be leading the delegation.
Okay. Thank you very much, GM. Just one. Thank you very much, colleagues. The briefing by
Recording in progress.
briefing by B-BBEE and the company tribunal on their first, second, and third quarter financial and non-financial performance for 2025-26 financial year. The purpose of the meeting is for the committee to receive briefing from B-BBEE and company tribunal on their first, second, and third financial and non-financial performance, given the available resources in terms of 2025-26 financial year. Oversight of their performance is an extension of Section 5 of the Money Bill Amendment Procedure and Related Matters Act 9 of 2009. This section of the Act requires that the National Assembly, through its committee, to annually assess the performance of each national department over the 18-month period and submit a report of the assessment known as each. I will now hand over to the DM and the team as per the allocated time to do presentations. Thank you very much.
Thank you very much, Honorable Chair.
Yes, just before Honorable Kodimbi, I will
Yes.
join. I want to request Member Chance to assist me chair this meeting. Because I have other commitment, but I will be in the meeting. Thank you.
Ladies and gentlemen, this is an important security announcement.
You can proceed. You can proceed, DM.
Okay. Thank you, Chair. Just to indicate, Chair, that I'm accompanied by the leadership of the department. The DG is with us, but won't be here for long because he has another meeting that he has to join. But the CFO is with us. The acting DDG, Dr. Susan Mangole, is with us, and then the Chief Director for Ops, which is Ms. Nontombi Matomela, is with me. And then I have the leadership, of course, of the B-BBEE Commission, is led by the Commissioner, Mr. Madonna, and the Competition Tribunal led by the Chairperson, Ms. Mondo Mazwai. Without taking up much time on the reports themselves, I just want to highlight a few things, Chair, that for the period under review, the B-BBEE Commission will indicate that for the 3 quarters, their average performance has been at about 82% against its targets. Of course, the variations per quarter will be explained. For instance, quarter 1, they had 100%, and then the slump was at 71% in the second quarter and 75%. But the 15% difference can still be recovered in the fourth quarter, and they will indicate what work will be done in that regard. The same or similar pattern will emerge with the Competition Tribunal as well. I don't want to get into the detail of what they've done to be reflected there, but a lot of the work that they were doing in the court has been impressive. They have sat through 124 cases, 78 of which have been measures, and there's been good performance in that regard. But the leadership will get into the detail of some of the challenges that they've had to contend with, and what remedial actions will they put in place to improve performance, or what reinforcement they need from us. With that opening, I will allow the B-BBEE Commission to set us off with today's presentations. Thank you very much.
Kotlimpi, thank you, Honorable Kotlimpi. Am I audible on the other side? And let me share my presentation once more. Is my presentation visible?
You're audible and your presentation is visible, Mr. Matola.
Okay.
Yes,
Thank you.
yes, you have visible, Commissioner. You can proceed.
That's it. Okay. All right. No, thank you, Honorable Mzandile Masina, the chairperson of the committee, Deputy Minister Kotlimpi, honorable members, DG. I'd like to appreciate the opportunity. We've had useful engagements with the committee previously on the work of the commission. We always appreciate your guidance. Today, we are going to present, as requested, on the APP that is in force with effect from April last year. So we're going to report on 3 quarters. And as you will see in the presentation as I go through it, I'm trying to move the slides. We will limit ourselves to the main outputs in terms of what was achieved and the challenges that we've experienced. I start on this slide about the functions of the commission, because the commission is a creature of the law. An overwhelming majority of what we do is what is asked of us by the law, and we do that to the extent of the powers that the legislation gives us, as well as the resources at our disposal. So everything has to be considered in this context, because this is what frames our APP. I show this slide, which is how we've organized our work. On the one part is the compliance, because the legislation says that, let me go back a bit, says that we need to oversee the implementation of the Act to promote adherence with the Act. I'm not going to talk about all of these functions, just the key ones. We also register major transactions that are 25 million and above. We analyze prescribed reports by JSE listed entities and public entities, organs of state. The legislation in section 13G says that all JSE-listed companies and all organs of state must submit compliance reports to the Commission. And I think this is probably the key compliance instruments that we have, the key compliance provision in the legislation for the Commission to be able to do its work. Because when we don't know about compliance, when there is no compliance, because there are challenges in this space, and I'll come to them, then it means that we are not going to be able to achieve the objectives of the legislation. So the most critical thing about our work is the compliance issue, as it were. But of course, we also investigate complaints. There's still a lot of prevalence of mischief, abuse of the legislation, circumvention. We investigate those complaints, as it were. So the importance of this slide is the kind of balance. We're struggling with the balance between what the legislation asks of us in terms of the oversight of compliance and the tools, the enforcement tools we have. Because we find that there are limitations in terms of compliance. And I'd like to make an example with fellow entities, even fellow entities in the department. SIPs, when you don't lodge your returns, when you don't lodge your reports, they deregister you. SARS as well, when you don't lodge your returns with SARS, you get fined. There are penalties. We don't yet have that, and it's a serious shortcoming. So we do moral suasion, as it were, and I think that in terms of enforcing, accountability for compliance, I must really appreciate the work of this committee. This committee calls various role players to account. It assists us. I think in the next round of amendments to the legislation, this is something that we need to be looked into. Consequences. There has to be consequences. Where the legislation asks of the measured entities I've referred to, but then we find that there's no compliance, as it were. Our work is also in regulations. Regulations, the act that says how we must do certain things. For example, complaints, we must finish complaints in 12 months. We must do complaints in 12 months. Advisory opinions, we must issue advisory opinions in 30 days. We must register major transactions in 90 days. And we must assess, as I've spoken about, these compliance reports within 90 days. And what we do when we've done that, we can give comments around which areas need attention by a measured entity. We give feedback and we monitor compliance with the feedback we've given, where we do get those reports. And then, of course, written clarifications within 5 days. There's always traffic coming to the Commission of people wanting clarification, interpretation here and there, guidance here and there. And I think what that means for me as a commissioner is that the legislation is working. It's embedded in the legislation. You will have seen BMF release a report on perceptions of BAE within the corporate sector, and many of the leadership of companies recognize that they have to comply with the legislation and they interact with the legislation, as it were. So the foundation for this legislation is in place. We just need to make sure that we enhance, our action. We enhance our game. Being the state and the private sector in terms of implementation of the legislation. I now come to to our performance in the period in question. The Deputy Minister has assisted me by indicating the average level of performance. So within the constraints of our resources, at least of the things which were asked for, we endeavor to perform. So let's look at the reports I spoke to. So we've received 187 in the period in question, 187 compliance reports, and we have assessed 157 of those, which is 83.9, let's say 84% performance. And these are organs of state from which we have received 76 reports and 106 from JSE. These numbers of reports, they vary, but I think that the trend line is towards a sort of reduced compliance, reduced submissions. So we need to reactivate the compliance with these sort of submission of reports. What we see when we look at these reports in terms of the scorecard performance on the targets, we see that in the period in question, 5 billion rand was spent on enterprise development, 5.8 on supplier development, and 19 billion for skills development. When I take the period since we've been monitoring this data, since 2017, 93 billion rand has gone into enterprise and supplier development based on information that comes to the Commission and that we monitor, and about 72 billion rand has gone into skills development. So those significant resources are being invested in the economy thanks to the legislation, the impact of which we can always do better, the quality of the spend, the quality of the compliance, we can always do better as we have indicated. And I think the transformation fund that the department has initiated picks up from this sort of level of performance that shows potential, but we're not necessarily, hitting the targets fully, as it were. In regard to major transactions, so in the period in question, we have assessed 11 out of 22. We have received 22 major transactions. Again, these major transactions, they come in on a monthly basis. We receive them on an ongoing basis. They indicate that there is still activity in the economy in regard to transactions, Black people acquiring a stake in companies, as it were. Again, of course, the numbers have stalled, and in the period under review, it's only 22 transactions. If I compare the equivalent period last year, at this time we were sitting at 55 transactions that are recorded with us, which are 25 million and above, and so on. But of course, we've come from higher numbers. I think the highest number in the period was about 258 billion rand of transactions a couple of years back. So across the board, the activity is stalling, still there, definitely, but stalling. And I think it coincides with the point where we are at, where we need to kind of review the trajectory of the policy going forward. We are at a sort of a turning point. We got to improve. We can't continue on this trajectory going forward. We have to up our game if we're really going to make serious stand to advance BEE and advance transformation. This slide is part of our monitoring activity. We do conduct site visits. We educate. There's still a need to educate people about the legislation and how it actually works. And so these are the numbers of the sessions that we have, which are always requested, by various stakeholders within the government and outside of government, for us to educate awareness and make people aware about BEE. This slide speaks to the compliance as it applies to the state. Section 10.1 says that when we procure, when we license, we have to have regard to the BEE credentials of the licensees or companies that we procure from, as it were. Now, the most important thing of procurement is that there was that judgment that said that the responsibility for setting procurement criteria, preferential procurement criteria, belongs not to the Minister of Finance, but to the entities that procure. And so we've been working with them to look at the extent to which they have policies and guidelines around preferential procurement, because there was a bit of confusion in that space, which resulted in procuring entities not considering BEE any longer. It was almost sort of understood that BEE is no longer a requirement, which is actually incorrect. And so we've been working with we started focusing on the 12 largest state-owned enterprises, the likes of Eskom, Transnet, and so on, working with them. So we're still ongoing work in that regard. And then looking at the bottom line speaks to the complaints that we have received. So we received in the period 66 complaints of fronting, various BEE-related disputes, and we have finalized 47 of those, which is 71.2% performance. 47 investigations reports have been released, but they fell outside the 12 months period. This is a very skill-intensive, labor-intensive part of our work. There's a lot of complexity involved in conducting these investigations. We have to get into the company, get into their financials and governance to be able to fully ventilate the complaint. So it does take some effort. But of course, we also encourage alternative dispute resolution. In the period, we have had one alternative dispute, subject to the parties. Sometimes the respondents say, look, we accept, we are guilty, can we make amends? We encourage that, because otherwise we must refer the matters to law enforcement, the police and PA. And we are not necessarily having any success in regard to prosecutions of BEE-related offenses, as it were. This speaks to our research work. So annually, we release a national status report, which is drawn from the data that comes into the commission through the reports I've spoken about, as well as BEE certificates. And in the period in questions, we've done an exercise that looks not on annual transactions or compliance, but look at a longer period. We went back to what is available data through the BEE certificates, because we officially, the instrument for measuring BEE is the BEE certificates, and we try to get as many of those as possible. We got about 28,000 BEE certificates from the period 2013, and we assessed the compliance, levels of compliance, achievement of targets, and that report is being finalized right now. It's been submitted to the department. The department will process it, and we'll be happy to come and engage with the committee. It makes for some interesting findings in regard to compliance with BEE, and the point is, the takeaway is, the policy is working. There is a trend line towards achieving high levels of compliance by companies, but of course over time, that the momentum on compliance has been stalling, and that's what we need to fix going forward. The rest of the slide speaks to our stakeholders. We've got a series of MOUs. And in a period in question, we've signed an MOU with the Companies Tribunal. The Companies Tribunal is a very important stakeholder for us because they are there to resolve litigation. Commercial litigation is very expensive, so they are there to assist with doing, quick resolution of disputes. And we are looking at sending some of our disputes, BEE-related disputes, to that forum. So we've done that MOU with them, and an MOU with an organization called Skills Quest. We've got many other MOUs, for example, the Financial Services Conduct Authority, and with universities, and so on. So those partnerships are very important. Success of BEE is also going to depend on how the ecosystem and how efficient that ecosystem is. With, for example, another big important stakeholder for us is the charter councils, and the department and the minister, convened a huge meeting with all of the charter councils, because for sectors, they are the first line of defense, if you like. They are the first authority, in terms of compliance in the various sectors, as it were. The rest of what is in the slide is the integration of technology in our work, digitization of our processes, so we're more efficient. And of course, we have a very important campaign of educating SMMEs around the legislation and what their rights and opportunities are in terms of the legislation, and also matters of corporate governance. In business, you can't be in business if you don't understand the rules. For example, sometimes people are in deals, they don't have shareholder contract or shareholder certificate, and they make elementary mistakes like that, which create disputes. So we're doing this work. As I said, we can do more, if we had more capacity. This slide speaks to our capacity. And you'll see the total number on the right of the slide. Total, it says 46, but effectively the Commission is still a startup. The permanent staff of the Commission is 27. The rest of the capacity we have is short-term contracts, 12 months contract, partnerships with NEF, who have seconded some people seconded from the TTI. So the issue of the sort of capacitation and proper establishment of the Commission is still a pending issue. But I do know that the Minister Tau has taken this matter seriously, and there are going to be processes that are going to resolve it, starting with actually having us established as a legal entity in terms of the PFMA, because the legislation says we'll be funded by appropriations from Parliament, but that's not going to be possible if we're not listed in the PFMA. So still, unfinished business in this respect, and I'm sure the department will speak to that issue. Again, because we're not funded appropriations, we get funded from the budget of the DTI, and you will see the numbers there in terms of what we get as resources. So it's a very lean and mean machine in terms of what we do. But I think that the ask in terms of the role of the Commission is far bigger. And in some ways, we're like a placeholder, for what actually should be a far more strong entity that has got a sort of reach reach that is required, and of course the impact in terms of what the legislation actually envisages of a commission like ours. I think this is the last slide. I'll stop here. Thank you.
You can have the next one, Member Chance.
Thanks, Commissioner. I suppose,
Andre,
Chair, we
would you like me
might
to
as
step
well
in?
proceed. Okay.
The next presentation, the people do have the rights to share the document.
Good morning, Honorable Chairperson Masina and honorable members of the Portfolio Committee, Deputy Minister Godlimpi, Director General, and colleagues from the DTIC. I am here with my colleagues. My name is Mondo Mazwai, the Chairperson of the Competition Tribunal. And I'm here with my two colleagues, Raji Mapanyo, who's the COO, and Sari Trebe, who is the CFO. Am I audible?
Yes, we can hear you.
Okay, all right. Okay. Thank you for the opportunity to present the Competition Tribunal's Quarter 1, Quarter 2, and Quarter 3 financial and non-financial performance. I propose to deal with 4 topics and give a broad overview on those. The first will be the year-to-date operational performance. The second will be our year-to-date financial performance. And then we'll look at the key strategic challenges that we have as an organization. And we'll then conclude about our human resources. If we could move then to slide number 2. Regarding who we are as the Competition Tribunal. We are an independent adjudicative body responsible for the adjudication of mergers and acquisitions. And in terms of our performance in the quarter that we are reporting on, being quarters 1, 2, and 3, we have achieved an average performance of 88% of our targets across all the KPIs. And in the year to date, specifically, we've achieved 99% of the targets in which we set mergers for hearing. We have issued our orders, 100% of them, within the 10 business days required in terms of the Act. As the tribunal, we do prioritize mergers because they are the lifeblood of the economy. And in the period under review, we had 124 matters, and 78 of those were mergers, which indicates that 63% of our work activity relates to mergers. Our average clearance period for mergers
Could I
is
just
12
ask that you
days.
move the slides forward, please? The slides are stuck on slide 1.
Yes. We are now on slide 5. Which
Thank
then
you.
speaks to our year-to-date performance. Member Chance, I will also just perhaps clarify. The COO will take us through the performance based on our KPIs and the targets that we have achieved. And the CFO will then later on take us through the financial performance. At this stage, I'm giving an overall overview of the performance of the organization from those 3 perspectives as a high level, and then we can get into the details if that's in order.
Thank you. That's fine with me.
I was indicating that mergers are the lifeblood of the economy, and in the period that we are reporting on, we had 73 mergers, 78 mergers out of a total of 124 matters, and we have achieved 88% of our targets. And the slide indicates the performance per quarter. We will deal with the targets not achieved in a moment when the COO gets there. I think what's important to mention in this part of the presentation is that insofar as mergers are concerned, the tribunal has had over 2,000 mergers since its existence in its lifetime. And in that period, only 17 mergers have been prohibited, and none of the mergers have been prohibited on public interest grounds. They have been on competition issues, and then some public interest grounds were applicable. We will come in a moment to our performance in respect of prohibited practices. As I indicated, we focus, and our mandate is about mergers and prohibited practices, those being cartels and abuse of dominance practices. And in that area, we do need some improvement, and we'll deal with that, and because that will be reflected when you look at the KPIs insofar as areas in which we haven't been able to achieve our targets. Moving to the year-to-date financial performance, which is on slide 14, our year-to-date performance reflects overall underspending against the approved budget. And that is to the year-to-date expenditure amounted to 45 million against the budget of 49 million, resulting in an underspend of 4 million rands. And this is primarily due to vacancies and lower operational expenditure. Recruitment processes for staff and the appointment of members is underway. And the slide that is relevant is slide 14, which relates then to the financial year-to-date performance. If I can then repeat, because the members didn't have the slide, is essentially that we have underspent by 4 million against a budget of 49. We spent 49, our revenue was 45 million. And as explained, the underspend is primarily due to vacancies where recruitment processes are underway currently. Then the third area that I will cover is the key strategic challenges that we have, and that is in regard to capacity. We'll move to that slide. Honorable members, notwithstanding the strong operational and financial performance as indicated, we have, as the tribunal, operated under some capacity constraints, particularly at a member level. The tribunal currently has 2 full-time members, which includes the chairperson, and 4 part-time members. In terms of the Act, the maximum number of members that can be appointed is 15, and a minimum of 3 members. The number of members is going to reduce further at the end of this month, as we will also lose 1 member due to the expiry of their term, and that will then leave us with 5 members. While we've performed well in dealing with uncontested mergers, for mergers that are contested, that take longer, as well as for prohibited practices, cartels and abuse of dominance practices, which take longer in terms of hearing days, they can run for up to 2-3 weeks even. We are not fully capacitated with 2 members to run those types of matters, and we rely on part-time members who are not always available for those extended amounts of time. And we will look at the caseload that the tribunal has. We mentioned that in the 3 quarters that we're looking at, we had 124 matters. This excludes the 240 cases that are active cases currently, which then brings the number of cases to over 300. And in order to process each one of those cases, we need a panel of 3 in terms of the Act, and one of the members on the panel must be a lawyer. And currently we have 1 full-time lawyer being the chairperson, and then 2 part-timers, and 1 part-time member's term, as I indicated earlier, is coming to an end at the end of March. This places severe capacity constraints and will impact on our efficiencies, which already have been impacted as we are building backlog on some of the matters that we could be. The next slide that's related to capacity is our human resources. And that's the organogram of the organization. We have a total staff complement of 30. And as indicated from the previous slide, we have 6 part-time members, 2 full-time and 4 part-time. We have the COO's office. We have with 3 people in that office. We have the finance and SCM office, which has 4 people. We have corporate services, registry, and case management. It's important to note the staff complement has remained marginally the same since the last organizational review that the tribunal undertook in 2015, where we increased the number of staff to 26. And currently we are 30 in total. And the capacity issues that I highlighted earlier are then clear just from the numbers and the volumes of cases that we have to deal with. We have undertaken an organizational structure review that was done in 2022-23, and that has recommended an increase in the number of staff to be able to deal with the mandate that we have in terms of the Act. So we currently have 34 positions that are funded and 35 positions that are not funded. It's important to mention that the unfunded positions are new positions mostly. And so it's not as if we have been operating without the full complement. This is still what we are working towards building on, in line with the increase in the caseload and the complexity of the matters. The intention is to fill the positions over time, and also dependent on budget. And so the timeline is in the next 3 years or so, we hope to have the full staff complement. We have identified key positions that need to be filled immediately, and the process for that is underway. And that should enable us to execute our mandate efficiently, especially in areas where we have not been able to meet our targets. I will stop there, and then we can, the CEO will take us through the specific achievement of our KPIs based on the targets that we set for ourselves. Thank you.
Thank you, Chairperson, and good morning, honorable members of the Portfolio Committee. So I will take you through the Tribunal's performance in terms of our APP 25-26 for the 3 quarters that we are reporting on. So we've divided our APP into 2 broad outcomes. One being sound, efficient, and responsive adjudication. So this largely speaks to our work as an adjudicator. And then the second strategic outcome is transparent, accountable, and sustainable entity, which is more governance related. And then across those two outcomes, we have about 7. So across those 2 outcomes, we have 7 outputs. And those then translate to 21 different indicators. 7 of those indicators are within the first outcome, and then 14 are within the second outcome, which is the governance one that I spoke of. So I'll go straight into our performance, looking at each of the different output indicators and how we've performed with those. So the first one, the chairperson spoke about the fact that because of our capacity constraints, our preoccupation is largely on ensuring that we process mergers quite quickly. Those are important, they're time sensitive, and like she said, they're the lifeblood of the economy. So you will see that our performance with regard to anything merger related remains quite high, and our targets are set at a very high level to ensure that our turnaround times are very quick. So the first output indicator is that we need to clear 92% of the cases that we merger cases that we receive. We need to schedule them for hearing or pre-hearing within 10 business days. And year to date, we've managed to achieve 100% of that. So what that means is that every single case, I think it's 99% actually, almost every single case that comes before the tribunal is set down for hearing within 10 business days. And then the second output indicator speaks to the issuing of orders. Again, for 92% of the measures, we have to issue our orders within 10 business days. And again, we do that for 100% of the cases. So this is quite important because it shows that the tribunal has prioritized, given the resources available to it, we've prioritized making sure that mergers are cleared quickly and we are not seen as a stumbling block to economic activity. The next output indicator is issuing of reasons. So once the merger has cleared and the parties are on their way to go and implement the merger, we have to issue reasons within 20 business days. And this target is set at 80%, and this is the target that we've been meeting for all the quarters so far, apart from Q3, but we've met it for the year to date. And then the chairperson spoke about the impact of our capacity challenges. You really start to see it when you look at our performance with regard to prohibited practice cases. So these are the cases, these are the contested cartel cases, these are the abuse of dominance cases. You would have seen, for example, the Air Link case that was just heard by the tribunal just a few last week, ending last week. So these cases are quite extensive in terms of the legal concepts that are considered. There's evidence that is led. Economic experts testify. So they are quite extensive in the kind of issues that need to be considered, and they tend to take long. So that target has been set at 120 business days for us to issue those decisions. But even at that 120 business days, it's a target that we have generally struggled with over the years, largely because of capacity. The chairpersons mentioned that we have 2 full-time members and 4 part-time members. The problem with part-time members is that they have their full-time responsibilities, so they are not able to be available to the tribunal on an ongoing basis. So when you have a hearing that's going to sit for 3 weeks to hear a case on abuse of dominance, it's very difficult to get a commitment from the part-time members for them to come and sit for 3 weeks. And then once they've sat for the 3 weeks, to get them to commit to actually writing the reasons. That's where you really start to see the impact of those capacity challenges that we have, and you see us then missing that particular target. And then the next target speaks to procedural measures. So these cases, we have 45 business days to issue our orders in 70% of the cases, but we've generally met this target quite well. Consent orders. So these are settlement agreements where the commission settles the case with the parties and they bring it to us for it to be confirmed as an order of the court. So in this target, it's set at 95%. This is a target that we have generally met over the years, but we had a challenge in Q2 where we received quite a number of these consent orders in a short space of time, and we were not able to clear these quickly enough. So you will see that we missed this particular target in Q2, but we've met it in the other years, and we should meet it also in Q4. So this is not necessarily, although we've missed the target, because it's an aggregation of all of the consent orders. It meant that because the consent orders in Q2 were a large number, it's largely infected our performance for the whole year. So it might ultimately mean that we missed this target for the year. But this is a target that we've generally met across the years, and we've met in all the other quarters. So it's not necessarily an area that we are particularly concerned about. And then the next target speaks to interim relief. We have to issue interim relief decisions within 30 business days. And this target hasn't been triggered. We haven't issued any interim relief decisions so far this year. And then so that closes off our first outcome. And then moving to our outcome on transparent, accountable, and sustainable tribunal, which are our governance outcomes. Here we have an outcome on communication. So effective communication and information sharing, which has 2 output indicators under it. So the first one is that we have to issue press releases for merger decisions within 3 business days. We do this quite well. Our system is quite efficient on that. And then the second one is, again, issuing press releases for prohibited practice. So these are all done once we've finalized confidentiality claims with the parties. And it's something that we do quite well. We generally issue our press releases quite quickly because we do understand the impact that our work has on the market particularly. So it's quite important to make sure that we inform the market once decisions are taken. Next set of output indicators speak to sound governance. So here we have percentage of prior year financial year audit outcomes audit findings that have been resolved. And we have to resolve 100% of these, and this is a target that we've met historically. And then our output in our audit outcome, we have a target that we have to get an unqualified audit. It's something that we take quite seriously. In the past financial year, we received our 9th consecutive clean audit, which is something that we are quite proud of as a public entity. And then the next set of targets speak to effective financial management. So this is percentage of expenditure against budget, set at 90%. We are currently sitting above that. And then the payment of suppliers within 20 business days, which is something we take quite strongly. It's set at a level that's higher than what Treasury expect, because the Treasury expectation is that we must pay suppliers within 30 business days. But the tribunal, alongside our fellow DTIC members, have set the target at 20%. And it's something that we're able to achieve every quarter. And then percentage of expenditure against with BEE suppliers. The commissioner of the BEE Commission will be quite happy to hear that all our expenditure goes to BEE suppliers. We've set that target at 100% to spend expenditure on BEE firms that are at BEE levels 1 to 4, and then 20% of our expenditure should be with firms that are owned by women, youth, and people with disabilities. Both of those we're able to meet every quarter. And we've never had a problem meeting that target. And then percentage of expenditure with exempt micro enterprises. Again, this is set at 30%, and it's a target that we've comfortably met throughout the year. And then we've got an outcome on transformation, capacity development, and staff retention and training. Here, the first indicator, staff retention, set at 80%. It's a target that we've not had a problem not meeting. The one target that we've had an issue meeting this year is percentage of staff training expenditure against total employee cost. So this target is set at 2% of our total employee cost that we have to spend on staff training. We've had a challenge meeting this target on a quarter-by-quarter basis. This is largely because most of our staff training expenditure goes to staff bursaries, where we have a number of our staff that are studying with institutions of higher learning, and then we also do training initiatives. But the largest proportion of that is staff bursaries, where staff is studying with institutions of higher learning. And we've struggled to meet this target largely because most of that expenditure is incurred at the beginning of the calendar year, which coincides with Q3 of our financial year. And you'll see that we had a problem meeting that target in Q1 and Q2. In Q3, there's been an improvement. There was an improvement somewhat as people started preparing for the next academic year. But in Q4, there's been a pickup, which we'll see we'll report on when in the next reporting cycle. But we've already been proactive in terms of finding a solution for this in our next APP, in the 26-27 APP, where we've made a change where this will be recorded as an annual target to basically even out the issue of that cyclical nature of the academic calendar. So we don't have to worry about having to meet that in every single quarter. We just need to make sure that we meet that target at an annual level, which is ultimately what we're concerned about. And then the next target there is a target on capacity building. We have to have one capacity building workshop on an annual basis. We had our annual capacity building workshop already in Q2. So that target is going to be met for the year, even though the target was initially scheduled for Q4. But because we already had it in Q2, the target is already met. And the number of interns, 2 interns. We have a target to have 2 interns in the tribunal. We've historically had 3. We've just lost an intern at the end of Q3 who got an opportunity to join one of the law firms, which is quite good because the idea is to train these interns and capacitate them so they can take up full-time employment. So we currently have 2 interns, and that's the target, and that's the target that we've met. And then percentage of employment equity representation, 75%. You would have seen in the table that the chairperson showed that our employment equity figures are quite good. We're sitting at above 90% in any year. And then the last target, similar to the BBEE Commission, we have a project going on to update and replace our case management system, introduce digitization into the tribunal. The target is a Q4 target for us to finalize the feasibility study. That's something that we're finalizing, and we shouldn't have a problem meeting that target. So that basically captures all of our targets in the APP. Like the chairperson said, our average performance is sitting at 88% for the year. I'll hand over to our CFO, who will take you through our financial performance for the year to date.
Thank you, COO. Good morning, Honourable Chairperson and Honourable members of the committee. So when you consider the Competition Tribunal's expenditure and revenue to date, you would note that the Tribunal has collected 91% of the actual year-to-date budget in terms of the revenue, where they've budgeted about 50.8 million rand in revenue versus an actual that they have collected on 46.4 million rand. And this is mainly due to the fluctuation of merger fees and fining fees where they're collecting fees. And this has resulted in a variance of 9%. Now, that variance, when considered in financial terms, it is an acceptable variance as the percentage is less than 10%. When we do consider the expenditure, you would note that we had an actual expenditure of 45 million rand versus a budget of 49 million rand, resulting in a variance percentage of 8%. Now, what is important to note with this expenditure is the fact that there is quite a large number of tribunal member vacancies at the moment, which is driving this underspending. And this underspending is then sorry, Chair. It's basically it's accommodated through the appointment of part-time members. And then, Chair, when we look at the capital expenditure, you'll note that there's a small amount of capital expenditure that the tribunal has incurred, amounting to 383,000 rand. That 383,000 rand was expenditure which was committed in the previous financial year, but the delivery of those ICT equipment only happened in the current financial year, and that then you will see that we had spent some funds there. Then, Chair, when we move on to the quarterly financials, here just to note that the tribunal did have less cash surpluses, as it's been eating into the surpluses over the years, which has resulted in lower interest being earned, and that is mainly due to the fact that interest is bargained on. The higher the investment, the higher the interest rate. The lower the investment, the lower the interest rate you can earn from that. We also had the merger filings that I have highlighted as well, which did result in reduced revenues. But what I do want to stop at, Chair, is just to note that there's an additional revenue of approximately 4.2 million rand that was allocated by DTIC, that we have not yet received at the date of this presentation. However, subsequently we have received it, and that was allocated with the intention of looking at the case management at the tribunal. Then, Chair, we also, when considering the expenditure, as I've highlighted, the underspending is mainly attributed to the full-time members vacancies. There was also a short-term vacancy in the CFO position, senior case managers, and senior competition law counsel vacancies. When we move on, Chair, to the quarterly performance, I've already spoken to the slides, so I will not handle it. But when we move on to the next slide, you'll see that the main cost driver of the tribunal is employee cost. And this is mainly due to the nature of the business. So 66% of our total cost is incurred in employee cost, while 34% is attributed towards operating costs. When we look at our strategic objectives there, our main side of the business, which also carries the biggest weight, is our sound and responsive adjudication. And this is where we are actually hearing the appeals and adjudicating the cases, which is one of our main cost drivers, while we are spending 45% on compliance of the organization. Then, Chair, when we move on to the challenges in terms of the funding, here just to note that we as the tribunal really do operate on a lean budget. Our funding has not increased materially in proportion with the increased mandate and complexity of the matters. We have received mainly inflationary adjustments to our budget since inception, and 64% of our funding still remains being generated from the government grant. 36% of our income is then also from filing fees. Now, the filing fees, Chairperson, also fluctuate depending on the merger activity, which does create a bit of an unpredictability for us as the tribunal, while our main cost driver is human capital intensive. So this results in with mainly 70% of our cost being incurred on personnel. So we also have had budget reductions and cost containment measures that have placed significant pressure on our ability to perform against the targets and planned expansions. We are currently having ongoing discussions with DTIC on the sustainable funding and the Commission on the percentage filing fees that's currently being received by the Tribunal, Chair. Then, Chair, I think that concludes my presentation on the finances. Back to the chairperson. Thank you.
Thank you, honourable members. That is the tribunal's performance for Q1, Q2, and Q3. Thank you for the opportunity.
Chair, I see you're still on the platform. Would you like to carry on, or should I step in?
Yeah, you can step
Okay, thank you very much
in.
indeed.
You can step in. I'm here. My hand is up, actually.
Your hand is up. Okay.
Yes. No,
You
just a
want to
quick. Yes, sir. So just a quick question to the B-BBEE to check with them whether B-BBEE Commission has been successful in having SOEs submitting their policies. If not, how is this affecting the level of compliance at the level of SOEs? So we've been raising this as a committee, this area around the role of SOEs in ensuring that there's full compliance with the BE policy. Secondly, the commission also talk about the B-BBEE compliance in various sectors. What is the impact of the sector code in various sectors and that are meant to facilitate real transformation? And there has been a lot of cases, I think, that we've been dealing with even directly as the portfolio committee, just to get a sense, especially on this that area of equity equivalent that is being proposed, or that is being talked about, especially as it comes to main big transaction. With regard to the tribunal, we asked some questions to the Competition Commission, and they never answered those questions. So I'm not sure whether or not the tribunal, as the authority in approving these deals, they can be able to take us into confidence. One of the questions we had asked, it was around the secrecy surrounding the HDIs partners within the approved measures and acquisition. That information is never published or scrutinized anywhere. Secondly, the fact that there is no centralized database of where you can find these HDIs. You have now a situation where there are repeats of individuals. If you can look into many of the deals that would have gone through in the 70 odd that we speak about, you'll probably find common names, so meaning that the issue of broad base is being compromised. And thirdly, we also spoke about how these HDIs get to be financed, because all of them, they get to be squeezed out of the deal. They are just there for compliance. After the deal, they are squeezed off, and then there are no mechanism to back or support them. As a result, they exit the deal. And lastly, there was an issue about the robust post-transaction monitoring system integrated with the commission, with the B-BBEE Commission, so that we can track the long-term transformational outcomes in the main. So I wanted to just raise those issues, Honorable Member Chance. Thank you.
Mr. Charles, Ms. Motsukatsi and Mr. Koza raised their hands.
I see that. Thank you, Andre. Ms. Motsukatsi, please go ahead.
Thank you, Chairperson. Let me also start by welcoming the report that has been presented. Let me say both reports presented. My question will be on the city tribunal. In terms of the presentation they make mention of their mandate to say that their mandate is to ensure that there is compliance, but they also indicate limitations in terms of, let me say, members of the tribunal in terms of making sure that those cases are being addressed. So my question is, what are they doing to ensure that they get all the members on board so that the cases can be looked into? The other question, they also mentioned that in terms of BEE activities, it's still stalling. And then my question would be, how are they going to up their game to ensure that they address the issue? And are they having any plan to address those issues? And then the other question would be, in terms of capacity, they indicated that they still need capacity because some of the people that they employ are part-time, others are partnership from other companies or entities. So when can we expect the commission to be in full operation? In this regard, one will need a time frame for that, Chairperson. And then on the other commission, or let me stop here for now. I will ask if there is another opportunity. Thank you, Chair.
Thank you. I think Mr. Muzi is next. Mr.
Thank you very
Khosa,
much.
please go ahead.
Thank you very much, Acting Chair, and the members of the Portfolio Committee, the two teams from the B-BBEE and the Competition Tribunal, the DM. Morning. So, Chair, I want to partly, I'm covered by your submission. I just want to check with the B-BBEE with regards to their APP. So maybe if they can go through that, I think page 6, 7, and 8. I'm worried, Chair, that their table doesn't explicitly reflect on the measures that have been put in place to respond to challenges. They are not telling us. They come here, tell us that we have managed to deal with the certain issues to this level, as if that is sufficient enough. What about areas where you couldn't reach 100%? What happens with the shortfalls? How are you planning to resolve them? Why are you not telling us? It seems as if you are here to tell us that we have achieved everything. Everything is fine. We mustn't worry about anything. But the fact of the matter is that these are not 100%. I can now invite you to perhaps number one, to check on the compliance and enforcement. Your report states that 83.9 of the section 13G report were assessed. Then the question then will be, what concrete enforcement action were taken against the remaining 16.1 that were not assessed or non-compliant? You didn't explicitly explain to us as to this is the challenge, these are the steps that we are planning to take, and this is the expected outcome in what time frame. You are not speaking to that question. And then also, of the 106 JSE listed entities as assessed through the Johannesburg Stock Exchange, how many were found non-compliant and what penalties or corrective action followed? The report doesn't speak about that. You are just dumping information to us without even yourself internalizing it broadly to tell us these were the findings, or this is what we have picked up. These were our performances, and these were our shortfalls. Don't you have shortfalls? And if you have, what are if there are backlogs or there are challenges, why are you not coming to tell this committee that you are having challenges? And what are the remedial actions that you are planning to put in place or that you have already put in place to correct what might have been a challenge? Also, Chair, I'm worried because I didn't get the sense that speaks to a real transformation in terms of accessing compliance. It doesn't speak to whether this compliance actually leads to real transformation outcomes or it is just a paper-based regulatory exercise. If they can also speak to that in terms of responding to their report or our question. And we have a crisis, Chair. I had a list of this. We have a crisis in South Africa where the B-BBEE have been infiltrated. We cannot entirely celebrate it because we know that it's been infiltrated by those whom were not supposed to benefit from it. We understand that there are those who are now becoming who are fronting in companies. So I want to understand, Chair, if with regards to the 19.6 billion in registered transactions, how much of this value represents genuine black ownership versus fronting arrangements? Because we must be concerned, we must be taken into confidence that these are genuine black ownership, or we are just doing a lip service, we are just ticking a box, whereas we know that we have a serious crisis in this country, which is opposed to the B-BBEE mission and the vision. And as you report, broadly explain to us that all these companies that you are talking about are genuinely transformed and are genuinely black-owned companies. And what mechanism have you used intensively to pick up that so that we, as we live here as a committee, we live carrying that in our minds that really the B-BBEE Commission is doing an intensive work. And also, only 50% of the B-BBEE ownership transaction were assessed. You are telling us that. But therefore, why are you not telling us as to what caused the failure of the to assess the remaining 50%? Was that your target? Is that sufficient to you? If not, what happened to the rest of the 50%? Why were they not assessed? And what mechanism are put in place, or what have you done to correct that? And what mechanism exists to detect and punish fronting? And how many cases have been successfully prosecuted? So you comrades, you come here, seemingly there are a lot of things that you are trying to hide from this committee. I don't understand. Because you are just here to give us a high-level report without revealing gross challenges that we know, and you know, as a matter of fact and principle, that these are serious challenges, but you speak less about them. It then gives us many questions as to what are we dealing with? Is there things that are happening behind the scenes which we must then take it upon ourselves to investigate? Because surely this is not sufficient enough. And also, it's worrying that you come to us to tell us that the Commission merely requests evidence from 12 SOEs instead of conducting direct compliance audit on entities such as Eskom, Transnet, and Central. The question is, why do you request for the 12 SOEs instead of conducting direct compliance audit in those entities? And just to also be brief, Chair, lastly, if the leadership can also assist us to understand that on the question on investigation performance, The target was 50% of the investigation findings produced within 12 months as per the report. Yet only 71.2 of the complaints were finalized, with 47 investigations missing the 12 months deadline. The question now is, what operational failures caused these delays? Because you are saying nothing about that. We must go out of this meeting as if everything is fine. But this is a serious crisis. And also be honest with us and tell us if really the commission have sufficient investigative capacity. Be quite frank with us. And lastly, Chair, on the alternative dispute resolution, only one of the ADR agreement was finalized. Why is the ADR so underutilized? And does this indicate low reporting or violation or weak enforcement culture? Thank you very much. I hope and believe that they will respond sufficiently to the question raised. Thank you.
Thank you. Mr. Garma, next.
Thank you very much, Chair. Good morning to all the honorable members. Good morning to Deputy Minister Kolimpi, Commissioner Matuna, and Chairperson Mazwai and your teams. Mr. Matuna, I felt a bit cheated today with your presentation. When I juxtapose it to the presentation that you gave to this committee last year, some of the things that were outstanding that we discussed and that you were going to bring back to the committee, for instance, was you were going to draft a bill or input for legislation in terms of how we can make sure that we enforce B-BBEE and penalize those entities that do not comply with it, especially in the JSE sectors. But if somebody would have arrived from Mars today and listened to your presentation, you would have felt some imaginary warmth that everything is hunky-dory, when we all know that B-BBEE in this country has actually gone backwards. We don't want the commission to be reduced just to report writing about outputs, because there's clearly some dissonance between the report that you are giving us and the outcomes and the radical changes that we expect in terms of the ownership structures of the South African economy. The B-BBEE Commission is there to assist us to redress all of the ills of the past and to move Black entrepreneurs from the periphery to the center. So we expected you to tell us about the progress you've made in terms of coming back to us about the enforcement legislation that we discussed at the last discussion, but also because there's been a lot of oligopolistic ownership patterns, and we were hoping that the historically disadvantaged groups would in fact be making progress in terms of the work that the commission does. So I felt a bit cheated today, but I think a lot of the members have raised the issues that I would have raised. And if you can maybe just inform us how we're going to deal with all of these issues. Thank you.
Thank you, Mr. Garma. Ms. Lazo-Webster.
Thank you very much, Acting Chair, and thank you for the presentations. I do think, the general sentiment that's been shared by the colleagues holds, even on my side. But I think my questions are then going to be a little bit more broader in terms of the work of the two institutions. I think my first is is for the B-BBEE Commission. Reports state that there's less than 1% of companies that are listed on the JSE that are wholly black owned. This is what reports say. They give an estimate of less than 1%. And I want to get a sense from the B-BBEE Commission of whether the monitoring of the ownership transactions, of compliance reports, actually look into that, because I think that's an important indicator, and whether they have a sense of what the actual level of Black ownership and control across JSE listed companies is, specifically on the ownership perspective. And then the second is around just a broad question, actually, and I think it's piggybacking off what we had raised in previous engagements with the Commission around legislation and around what has to happen with legislation, and how we then have to work with the Commission to see to it that the legislative side of this, we're taking our role in terms of that, guided by them, in terms of what needs to change to be able to actually realize the transformation that we had hoped that this policy would actually achieve. So it's to ask whether, if I were to ask you quite directly, as a commission that is working in this area and that is tasked with compliance, and assessing the extent to which this policy is indeed achieving transformation, I'd ask whether really is it creating new large Black-owned companies, or is empowerment primarily taking place within existing corporate structures? Is it primarily taking place within mergers and acquisitions? Because you see, if ultimately what we're not seeing, what we ultimately don't see, is the creation of new large Black-owned companies and players, and that's why in my first question I referred to the JSE, then it means that, we might as well pack up and start all over again. So that is the question that I'd really, really want to have quite a direct and honest reflection from the Commission on, so that we're all able to take a step forward that helps us to realize what we wanted to realize. And then there are companies here that reported billions. I mean, I don't have the exact figures in front of me, but in enterprise development and supply development, is the Commission verifying that these funds are reaching genuine Black-owned small businesses? And even some of the geographic placement of these businesses, are any of these, as an example, township enterprises? Is there any sort of tool tracking really the bona fide list of these firms that are receiving enterprise and supplier development spending and funding, and even, where they sit and how far they are in their review of these Section 13G compliance reports? And then lastly, to the Competition Tribunal, when the tribunal assesses mergers, how often are public interest conditions that are related to transformation or to ownership resulting in meaningful changes to ownership structures? Because it seems that the trend or the pattern is that they ultimately resulting in temporary commitments or supplier development conditions. But is there really instances where they translate to, or they result in public interest conditions that relates to transformation, that relates to ownership, more than they do to commitments to supplier development, etc., etc.? Thank you.
Thank you, Ms. Webster. If I may ask any other questions from committee members, otherwise I will ask a few myself.
There are no further
Okay.
hands, Mr. Chance.
Thank you, Andre. So I think it's clear from the presentations that we received this morning from the Commissioner and the questions from members why the committee last year in a report recommended that the Minister implement a full assessment of or review of the efficacy of the BEE legislation. Because even under its own terms, the Commission has reported very dismal results. So, for example, if we look at the number of companies that have reported, it probably represents less than 20% of measured entities in this country. And I'm not just talking about listed companies. I'm talking about companies with turnover of over 50 million. There are probably up to 1,000 companies in this country. I don't have the total number at hand, but it just indicates there's a lack of compliance fatigue, I would suggest, or just a general disinterest, and that cannot be good. It cannot be good for the legislators who are expecting this legislation to actually have force. So that then begs the question: what is happening to the review that Minister Tau committed to? And perhaps the Deputy Minister Godlimpi could update us on that. Has the review commenced? Have the panel members been selected as a reference? Does it have a reporting date? But of course, underlying this is the question of, should we be having BEE at all? And I'll leave that to another discussion. But compliance is not just about reporting. It's about what is the impact on the real economy. And what we've seen today is it bears absolutely no relation to the real economy at all. It doesn't talk about economic growth. It doesn't talk about the number of new companies established, as Mr. Webster was intimating. It doesn't talk about jobs created. It just talks about reporting. And in my view, that is just not good enough. And I do have to refer to Minister Tau's comments at the recent sector meeting, the sector codes meeting, that the whole business of transformation, or at least bringing more Black people into the economy, into the productive economy, has to focus on outcomes. And whatever BEE legislation there is in place, or whatever transformation legislation, or whatever you like to call it, redress legislation, the focus has got to be on economic growth, job creation, enterprise development. That's really why my first question is, why have there been such a small number of measured entities responding to the request for reports? And as Mr. Koza said, what consequences are there? And I'd like to ask Mr. Matona, what type of penalties would he envisage? I mean, he talked about CIPC and SARS. Of course, they do have sanctions, they have fines, they have deregistrations. What would you expect, Mr. Matona, that the legislation should provide for in terms of penalties? What would you want? What powers would you want the Commission to wield if the companies that are expected to report do not report? Again, if I look at the number of certificates which have been, I think you talked about 28,000 BEE certificates have been submitted since 2013. Now, there are probably, I don't know, 500,000-600,000 registered active companies in this country. 28,000 is a paltry number. Again, it just indicates lack of compliance and a disinterest and compliance fatigue. So on a more sort of granular level, I'd like to know, how is the 8.7 million Rand over expenditure being funded? You mentioned that in your numbers. Where is that money coming from? Is it just a grant from the DTIC? And I know that you're not a separate entity in terms of the Act, but you obviously have to get the money from somewhere. Turning to the Competition Tribunal, this really does indicate, Chairperson Ms. Y, a significant problem that has been with us for years, and it's having a major impact on South Africa's competitiveness and our attractiveness as an investment destination. And the underspending of that 6 million rand is a serious problem. And my first question is, why is it taking so long to fill those vacancies? I mean, with a maximum of 15, you've only got 2 full-time members, including the chair. I mean, that's a catastrophic situation. What action are you taking to fill those vacancies? Remember, they are funded vacancies. They're not talking about just unfunded vacancies. And again, the question should be also directed at the Deputy Minister, because ultimately he takes responsibility with the Minister for South Africa achieving its policy objectives of attracting investment. And we all know that mergers and acquisitions is a fundamental element of any competitive economy. And if these businesses are not attracting competitors who are, looking to improve competitiveness, why is that? And how much of it is due to the fact that we just are not seen as an economy that has got our act together? I have a question also relating to the takeover regulation panel, who we heard from yesterday. When does a merger become a takeover? And this then, leads to the question as to when a merger is reported, at what point do they actually have to go to the takeover regulation panel? Is it when a majority of shares is acquired? And what is the regulatory framework for managing those 2 types of commercial activity? Yes, I have one more question relating to the filing fees. 36% of revenue comes from filing fees. When were these fees last reviewed? You did mention in one of your slides that there was a discussion around this, but I'd like to know, when were those fees last reviewed? So, for example, when we had the National Credit Regulator last week, they were talking about debt counsellor fees haven't been reviewed for 10 years, which obviously means it's more difficult for these people to stay in business. If you were to increase your fees, would that mean that you would depend less on the state? Presumably it would, but have you got a request in with the ministry to have the fees reviewed, and if so, by how much? So I think let's take the B-BBEE Commission first, and then the Competition Tribunal, and then we'll have the last words from the Minister, the Deputy Minister, if that's okay. So, Commissioner, do you want to kick off? Commissioner Matona, are you there?
Yes, he's there and is not muted. I don't know why he's not. Commissioner?
Yeah, he is muted, but he's not responding.
Chair, maybe there's a technical problem. May I suggest we proceed with the next presenters, Chair, until maybe we can find out what's happening.
Okay, let's go to the Competition Tribunal. If we could have Ms. Wise starting off, please, or whoever you direct to speak.
Yes, thank you, Member Chancellor. Member Chance. Just starting then with the question that came from the chairperson of the committee, Mr. Masina, regarding a request that they put to the Commission in respect of the issue of the secrecy around HDI beneficiaries and conditions, as well as access to that kind of information. Let me take those 2 questions first. I'll deal with the others after. So the tribunal can only direct the Commission to do something after there's been a complaint at the tribunal and a hearing, and therefore an order that's based on a review of what the issues are that have been brought before the Commission. And our mandate is really about the enforcement of the Competition Act. So the complaint would have to be a complaint related to an anti-competitive practice. There are other instances where there can be a complaint that is brought on the basis of a breach, for instance, of merger conditions that we have imposed. And so insofar as HDP secrecy is concerned, that tends to come mainly from the merger conditions that we impose. And insofar as getting access to that information is concerned, there are two things I think that are important to mention: that when parties file transactions at the Commission and at the Tribunal, they file what is called confidentiality undertakings over matters that they consider to be commercially sensitive. And the Act does provide for them to claim confidentiality over those areas. That confidentiality claim can be challenged before the Competition Tribunal in terms of Section 45 of the Competition Act. And following a hearing on whether that confidentiality claim has been validly made or not, the tribunal can then order that that information be disclosed. So those would be the avenues that would be open in terms of then gaining access into who the HDP beneficiaries are, in terms of how the tribunal can get involved. It's only through an application to get access to that type of information, which would have to follow a hearing. There are instances where parties do agree to waive confidentiality, where the Commission asks them to do that. And in certain instances, when a matter is before us, we do try and ask the parties and facilitate the waiver of that confidentiality. But if the person claiming confidentiality doesn't agree to it, then a formal application has to be brought. In terms of a database for who the beneficiaries are, the tribunal doesn't necessarily have a database. We do have a database of all the conditions that we impose. And I think the Commission, in terms of their monitoring provisions in the Act, do have obligations to monitor whether the conditions that we impose that direct that HDPs be beneficiaries are being complied with. We don't see that part of the compliance and monitoring elements. That's done by the Commission, and the DTIC is also normally informed about the monitoring obligations. Those typically happen annually on the parties who have the conditions imposed on them. And so I'm not sure whether the Commission would have that type of database. I am aware, even for ourselves, as we have to report on different aspects of the work that we do, we improve our case management systems to incorporate new areas of reporting that we are required to do. For instance, on the issue of our spend on BEE entities, on women, on youth, we have had to monitor and track that kind of spend for purposes of compliance. So it is something that can be done, and it's done obviously as the need for particular reporting happens. But I think at this stage, for centralized database of HDPs and beneficiaries, we don't have that, and it may be that the Commission has that. Insofar as who these beneficiaries are, and the question about them being continuously the same individuals, we do have a provision in the Act that speaks of a greater spread of ownership. So when we do assess mergers, we look at whether the merger has an impact on a greater spread of ownership. And recall that that provision came into the Act in the amendments of 2018, precisely to try and ensure that there is a broader element to ownership. In how it plays out in the Competition Tribunal is through mergers and acquisitions. We have, and for some time, we saw conditions that involved ESOPs, which provide for a greater spread of ownership in several mergers where the mergers were approved subject to the merging parties also establishing an ESOP so that there is benefit to a greater spread of or to a greater group of previously disadvantaged persons. So that's in one respect that we have seen that. Insofar as the financing aspects are concerned, we don't typically get into the commercial arrangements and the financing of transactions. What we are able to do, where appropriate, based on the case that's before us, is to order conditions that involve a divestiture to a specific group of people, often HDPs, but we are not able to get into the area of the financing elements and who should finance, and because that's then left to finance institutions, and we unfortunately don't have much that we can do in that regard. On the post-monitoring and tracking question, I think I covered that parties are required to then report annually or as often as required in the conditions to the Commission and to the DTIC, which then are able to track as to whether the conditions are being complied with. The one element that I think is often underestimated is, and I think the Commissioner of the BEE Commissioner mentioned this in passing, monitoring can also be quite an intensive and human capital intensive process, because you do require people who are able to then do the monitoring. If I think of the number of conditions sometimes that are imposed by the tribunal, let alone the ones that the Commission may impose themselves for intermediate measures which are decided by the Commission, you can have quite a number of matters that require monitoring. And as far as I'm aware, and I speak under correction, I think the Commission has a monitoring unit that comprises about 2 or 3 people. So to meaningfully monitor, you also need resources to see the impact that one wants to see. I'll then move to the questions that were posed by Member Musikati. The question about capacity is one that was also asked by Member Chance. What we are doing as the tribunal in that regard is that we have been liaising with the DTIC because, as we indicated in the presentation, the appointment of members is made by the President on the recommendation of the Minister, and the process has been underway to appoint members, and there have been processes that have been followed, and perhaps the DM can speak to where things are in that regard, but there has been movement to fill the vacancies and to improve our capacity insofar as members are concerned. The other 2 questions from Member Musikati, I think, were for the BEE Commission. So I'll move to questions regarding the public interest issues that were raised by Member Webster. So the question was about whether the tribunal does anything insofar as the public interest elements are concerned, other than supplier conditions that are often part of what the tribunal orders as conditions to a merger, and whether there's meaningful transformation that arise from mergers. There are instances where the tribunal has ordered divestiture of businesses to HDP entities, and an example that I can mention is one where Shoprite was going to acquire Massmart's wholesale and liquor businesses, and there were some competition issues arising from that transaction, And after a long hearing, we identified certain areas where there was going to be concentration, particularly in low end consumer areas where there would have been a concentration. The tribunal ordered that certain 10 stores be divested to HDP entities. And that is one of the ways in which we can see that there's meaningful transformation to have businesses that are divested to HDP entities other than just the supply conditions. Another area I mentioned earlier, the ESOP conditions, which also aim to transform ownership in a more meaningful way and to different categories of people in the country. Then there was a question about the takeover regulation panel and the interface with mergers. So mergers are notified to us whenever there's going to be a change of control as defined in the Act, and that can be from acquiring more than 50% of a business, sometimes less, depending on whether there's going to be minority protection, such as vetoes over budget and significant commercial strategies of the business. As far as I understand the takeover regulations, is that they protect minority shareholders in companies, and they then would have an overlap with competition authorities, which has sometimes happened, but their mandate is really to protect minority shareholders to ensure that they receive value for the sale of the shares that they have. And so the mandates are different, but there's an overlap as to mergers can lead to the takeover regulation panel having to consider whether the minority shareholders are getting fair value. I hope I'm correct on that element, but the overlap is there in that sense. And then the next question was about filing fees and when they were last reviewed. The minister issued a gazette in January this year, which was inviting public comments on the increase on filing fees, and thresholds for notifying mergers to the competition authorities. And so that process is also intended to deal with this issue of filing fees and revenue generation. The commission is, this is part of what the commission's functions are, together with the DTIC, the minister. And so that process of a review happened as recently as January. There is another element, which is the sharing of the fees between the Competition Commission and the Tribunal on filing fees that are filed on mergers that are filed with the Commission. And in that regard, we are in ongoing discussions with the Commission, because the percentage of fees that the Tribunal receives from merger filings has also not been reviewed in a very long time. But those discussions are ongoing with the Commission, and were ongoing even as late as last year. What put things on hold was also this regulation that came out in January to revise the filing fees, because it will also impact the discussions on the split between the Commission and the Tribunal in terms of the filing fees. And so we anticipate that once the regulations on the merger thresholds have been finalized, we'll be able to also finalize the discussions on the merger filing fees between the Commission and the Tribunal. And I think those are all the questions that were asked. I'll stop here and take any further questions. Thank you.
Thank you. Can I then ask the Commissioner, the B Commissioner, Mr. Matona, are you back on the platform?
Can you hear me, Chair?
Yes,
Member Chance?
we can.
Okay.
Yeah, please continue.
Sorry, I had a technical glitch earlier on. Let me appreciate members for very important questions. All of the questions that have been raised are very, very good questions. Let me also indicate that I'm joined on the meeting by some of the senior members of the Commission who are responsible for various areas, and they may be able to come back. I'll ask them at the end if they have anything to add, but let me deal with the questions. So Honorable Mzwandile Basina is asking about the response rate for our request to engage with the policies, and I'd like to also explain, put that request in context. So far, we have had our report indicates where we've gotten responses, and those entities have shared with us their policies, which we are currently going through just to assist them. We expect that the others, for example, the large ones, like PRASA and so on, that we will still get to those ones as best we can. So my office is following up on the other, so we can try to do as many before the end of the financial year, or at least receive as many before the financial year, and as possible, because that's a target for this financial year. We pick up challenges with this area of compliance with Section 10, which says you have to factor in BEE and have established processes, institutionalize how you deal with these matters of procurement rules, preferential procurement, licensing, and other authorizations. We pick it up when they report. So by and large, the main state-owned companies, they report on BEE, partly because they do business with other emergent entities who are concerned about their compliance, as it were. So they, in terms of also corporate governance, they have boards, they have compliance systems in the companies. So they do report. However, when we examine their reports, we see that there are these challenges, and the one that we are focusing on is around procurement, because of the confusion that was created in that Constitutional Court judgment that devolved authority to set criteria from the Minister of Finance to the procuring entities. So it's work in progress in that regard. And by the way, I engage at CEO level. I engage with the leadership of these organizations. That's what has been encouraging. I've written to them, and I'm engaging at that level of leadership. Where we think, Chair, we can need your assistance in unlocking this, we will come back to you, because I do think that Parliament, in terms of your mandate of accountability, is going to help us. We need it. Our own authority and power, is limited, as I've explained, as it were. But we soldier on and use all opportunities that are available to promote compliance, particularly within the state, as it were. The sector codes are a major challenge, and the department, because they report to the department, by the way, they don't report directly to the commission. This is another thing that we need to fix, so we don't fragment the oversight regime in this way. But they are gazetted by the Minister of Trade and Industry, who gives puts them into law, gazettes them into law, and therefore they report to the minister and to the department, and then we get a report. Of course, we get copied the report of the sector, and we look at it as well. They have similar challenges. They have similar challenges of non-reporting by entities in their sector. They have challenges of the governance structures, the oversight structures. These councils are supposed to be councils. They're supposed to be funded partly by government and by the private sector in a particular sector. All of this is not necessarily working very well. And that emerged in the meeting that we had. So we got to fix that ecosystem, of sectors as such. So I think, Chair, you pointed in a very important area, and I'm sure you will as you engage with them, because I know for example, the Financial Services Charter, they have a pending appearance in the committee. They will share some of these challenges, but I'm aware of them. They express these challenges when they met the minister. So this is quite something to be fixed there. Honorable Mzandile, I didn't hear your question around the equity equivalence. We can come back to it later on. Let me deal with the rest of the other questions, because they speak to the issue of where are we at with the transformation through the instrument of BEE. And Honorable Gama, when we came to the committee, that was the topic that we came for. So we did a full-blown discussion on where are we at and the challenges of transformation. This time around, we came to deal with the APP, and that's the slight difference. We didn't prepare a full-blown report on the state of transformation. I think we may need to come back to that sort of focused deep dive, if you like, into the state of transformation, factoring in the work that we're doing, but the work that's been done elsewhere on transformation. There are other actors, stakeholders who also monitor transformation from different vantage points, as it were. But I'll come back to some of the issues that have been raised in respect of that. So what is the state of transformation? I want to deal with the questions raised by Honorable Muzi. I'm sorry, sir, if I didn't convey adequately enough that we are reporting against annual targets. So the percentage achievements that you see are percentage achievements in relation to the annual targets. So the annual targets you will see typically will be 100%. So we are at a particular point. We still have this quarter, for example. We're not dealing with this quarter. If we were to report to date, those percentages will have shifted forward, as it were, because the request was to only focus until Q3, and we've stayed loyal to that. So in other words, I'm saying some of these targets will still be achieved within this financial year. So we did not withhold any information, and we cannot conceivably, as a commission, come to Parliament to mislead or deceive parliaments, as it were. So So the presentation is structured in that way and has to be read and understood in that way. Let me deal with the other questions. You talk about enforcement of non-reporting. I did speak to this in my presentation. I did speak to the fact that the legislation says in 13G all JSE listed entities, organs of state, public entities, all must submit reports on their compliance with the Commission. That's the language. But it doesn't say, nowhere does it say, the Commission, in the event of non-compliance with this provision, must do X, Y, Z. And that is a problem. That is a problem. So there are others who appreciate the role and the importance of the Commission. They respond. There are others who report because it's important for governance, for their own governance. But for the rest, there is a habit of non-reporting or inconsistent reporting. 1 year they report, 1 year they don't report. So this issue is very important. We've got to fix it. Because when we do not have reports, we do not know where we are at. And my sense is that those who don't report probably are not implementing. So they've got nothing to report. The universe, the population universe, Honorable Chance, in terms of that specific provision, which is what we're limited to, JSE listed and public entities, is kind of about 500, more or less, rough rule of thumb, 500. But it doesn't. Those are not the only entities that are performing, implementing BEE. Others. It's in transactions that they do. We get their BEE certificates. Remember, they have to submit their BEE certificate. So we have a wider view of the landscape in terms of implementation and who is supposed to be implementing. And I might also indicate, when I spoke about 28,000, there are about 89 verification agencies who are the ones who issue BEE certificates. So that 28,000, we got those certificates from 59. Others, and that's another thing, by the way, that needs to be fixed in amending the legislation, discipline of the verification industry and the professionalization of the verification industry, in terms of how they keep information, because they keep public policy information. There must be protocols and standards in terms of how they must keep that information, and how that information can be made accessible. We struggled with that when we were trying to gather data. So again, I highlight an area of challenge that needs to be addressed. But I did speak to the issue of the challenges of non-reporting. I was, and I suppose let me conclude that by saying this, that we are only as good as the law that we work with, that has created us ease and the capacity that we have. We are only as good as the law that has established the Commission and the capacity of the Commission. The issue of the line of sight. So we receive reports and there are BEE certificates, and we are limited in terms of what we see to the information on a BEE certificate. For a while, I have felt that this is inadequate. The design of the measurement, because again, is what the measurement is. The legislation said we will measure with a scorecard, and it's specified what that scorecard must contain. And we get that, but it doesn't really give us a sense of the reality that lies behind the numbers in the scorecard. So the reach of our oversight is limited in that way. We must change the rules such that we have more visibility to impact, and that is a priority issue. One of the critical areas of intervention when we fix the legislation is to also integrate impact indicators, so we're not limited to the certificate, as it were. So it's a very, very important issue. And I think it's recognized everywhere, that is a limitation of BEE, that it doesn't give us full access. So you ask about our process of assessment, for example, of measured transactions. Exactly the point you make. That's what we are looking after. When we look at a transaction, we look at who are the Black beneficiaries. Are they really Black? What is a proportion of their benefit? Do they have shareholder agreements? We look at the shareholder agreements. We thoroughly interrogate those transactions. We ask for ID numbers in each of these. So we're quite thorough. But it is the design of the report today was not such as to enable us to get into that level of detail in terms of our processes, as it were. But I'd like to assure you that we watch the interest of Black participants in transactions like a hawk, and we send those transactions back. We say, go fix this transaction is not designed in a way that is going to benefit Black people. Go fix it, and so on. So that's where you see the disjuncture between the numbers that we have assessed and registered and the ones that we have received. So that 22 in that number includes those that we have assessed and that we've either approved them or given them feedback, and the rest are still within time frames. And again, that's how those numbers should be understood. The audit, we don't have audit powers. So in regard to state-owned enterprises or organs of state, you are right. We have to work with the Auditor General, and we do work with the Auditor General. The Auditor General does look at BEE when they audit, but they look at it in terms of performance information. We'd like to strengthen that area to have it also established as part of the template, the framework for conclusion of corporate plans, APPs, and that is going to require Treasury, the Accountant General, because the Auditor General only audits a framework established and approved, authorized by the Accountant General. So we have that sort of framework strong and robust enough to help us with compliance, so that we rely on the audit, the audit function and its powers in terms of also helping us with compliance. Operational failures around investigations. This is a very important area of challenge. Now, of course, I spoke generally around the capacity challenges. I didn't link them to any specific function that we perform, but it's very acute here. At one stage, we were working only with two investigators, full-time investigators. We outsource. Some of this we outsource to the law firms, forensic investigation firms out there. We have a panel of them that help us a great deal, but we must still vet those reports, as it were. So it's one of the capacity challenge areas that we are hoping, as a commission gets capacitated and properly established, it'll help us. We have a backlog. in regard to investigations. I think that backlog has been building over time. We have not been able to meet the 12 months. So the backlog is matters that we have not been able to finalize within the 12 months. I think it's about 300 or so backlog that we've built over time. The total number of complaints we have received since we came into office is about 1,500 or so complaints, of which we have a backlog of 300, as I've indicated. You asked about, or two questions you asked about detecting fronting. We detect fronting to the extent that something is submitted to us, either a report or a major transaction, and we examine it, and sometimes we are able to pick up where there's fronting, but we have no way of sensing who is fronting out there. It's a reactive function. Sometimes we do get people who whistleblow. Some of the front offenses on the legislation we get through whistleblowing, but we have no way of getting inside every discussion, be a business discussion that involves BEE, to be able to detect fronting, which is the way you phrase your question. But yes, some we are alerted, and some of it we pick it up in our assessments. As such, why is ADR underutilized? ADR is voluntary. We have no, the legislation does not empower us to impose, if you like, settlement between the parties. When we have made adverse findings, we ask of a respondent, are you willing? Because usually there'll be a number. We will calculate that the black partner, this is how much is due to the black partner. And sometimes the respondent is willing to do. We just reported in the period. The one is the period, but there's quite a high number of ADRs. Maybe my colleagues will assist me. This one is just for the period, but we've been doing this for a while now. These ADR, we have a standard agreement that we just sometimes put the names of the parties and the terms of the settlement in terms of amounts, and it's a well-established function. But again, we can't set a target and say we're going to do so many, because there's a dependency on consensus and agreement in the parties. As I conclude this part of your questions, Honorable Muzi, and maybe asking the committee for the next round, if we can get further guidance in terms of how to package our report, in which areas we should sort of elevate, as it were. So we stayed close to the template of our APP, but maybe there's we can get, if you like, suggestions of how, how to, and what sort of level of detail we should bring to the meeting. Something for the committee to can assist us with. I think I've dealt with the question from Honorable Gama around the difference. Last time we are going to report on the state of transformation codes of good practice. It was an excellent discussion, out of which you are right. We then there was a suggestion that the legislation should be amended. There must be a review, and there must be a roadmap. We don't write the rules as a commission. We are the referee who gets given the rules. The rules are determined by the minister as a legislator, and the department. And as I understand it, and they can share with the committee, they are setting up shop now to actually embark on that review. I believe the roadmap was sent around what will be the approach, what are the areas that need to be attended. But you're quite right. This is the next big area of focus and activity in the coming financial year. We have to drive this review, put aspects of it on an accelerated process. Some areas will be challenging, will be difficult, but there is no issue whatsoever that we cannot have the legislation reviewed, and it can address some of the weaknesses that are giving the legislation, if you like, reputational challenges in terms of its effectiveness. Those things can be fixed, and we as a commission, because we work with the legislation in a different way than anybody else, we've been feeding back some of those challenges and areas and how they can be fixed to the department. So that definitely is going to be the show. The president spoke about it, and we are instructed from the SONA, to embark on this review. The BEE ownership on the JSE. This is an elusive number, Honorable Hlazo, website. This is an elusive number. When we ask for reports from JSE listed entities, and of course, as I indicated, not all of them report. We only look at ownership, level of ownership of those entities that report. It doesn't give us a full picture of the ownership, overall ownership, black ownership on the JSE. But there are other people who do research, different research, primary research, going into the annual reports of the JSE. One of them is, Duma Kubla, economist Duma Kubla, who's a commentator and analyst on BEE. In fact, he's publishing a latest report on black ownership on JSE, and he told me it debunks the myth that BEE is only benefiting 100 politically connected. He says there are no politically connected persons in the ownership numbers on JSE that he's looking at. So his number was between 4% and 5% black ownership, largely driven by also private equity, PIC participation. PIC is a significant participation, and part of its ownership is designated black. However, I must concede it's an area that we need to have to be much more clinical in terms of assessing. It is true. I think that there is still no 100% black-owned black-owned entity on the JSE as we speak. You are saying, is the commission creating new black-owned companies? It's not. I don't understand the legislation to actually envisage that the commission is active in deal making, or even supporting companies directly. That's a broader responsibility of the state and the economy. We just look at the instruments, whether the instruments in the law that support that, like ESD, we monitor that and we track it and we look at how effective it is, whether it's being complied with as it says in the law. I agree with you. I do believe that instrument is a potent instrument, and I'm glad that the Transformation Fund is building on it. To put the instrument that helps us create black-owned, even 100% owned, black-owned companies, to add to the army of SMMEs and enterprises that are going to give us the growth and jobs we need, as it were. I spoke about the impact. If there's one area of research, I think, focused research deep dive which will build on the one we did, is actually going to look at impact and impact assessment of ESD, if you like. We know that it's not honky-dory, to use Honorable Gama's term. It's not all honky-dory. We get a lot of complaints, participants of ESD, Black participants of ESD, complained of being trained to infinity, when actually what they do is to run their businesses. So the quality of compliance on ESD absolutely can be better going forward. Honorable Chance, I think you spoke about the efficacy of the Act, and I've kind of spoken to it, and the department, I think, will deal with that. You speculate around the reasons for the stalling of the momentum on compliance. I think it's subject to investigation. I think it's the incentives. It's the incentives in the legislation. If people see that the legislation doesn't really incentivize them to comply, so part of it is going to be fixed by changing the legislation. Part of it is going to be achieved by the state taking BEE seriously, because the design of the legislation is that you don't have to comply, but if you do business with government, then you have to comply, and on the other side, government must then also look at whether you comply. So we got to fix that. Absolutely, I'm not saying that. And as I conclude, honourable members in the committee, forgive me if I created a picture that all is well. All is not well, but it's not doom. It's not doom at the same time, and we shouldn't be fatalistic. BEE is not a story of complete failure. I think there's still scope for us to optimize this tool and make it work effectively. It is not the answer to all our economic challenges. It has a role, but it must work with other policies if it's going to deliver the jobs and the growth. It was never designed to carry the full responsibility on its shoulders for job creation. But all of your points are good points. There'll continue to be talking points as we engage further on this policy. Penalties. The simple, basic sort of benchmark is in relation, for example, to reporting. Is the administrative penalties, which I think the Competition Commission uses. ITAC, the International Trade Administration Commission, uses in terms of when you are required to file something, there has to be consequences, because that requirement doesn't exist in J&J just for nothing. It's crucial for public policy to work effectively. The reporting is how the country knows how far we are, how are we doing. So it's important like that, and it cannot be that it can just be ignored. So I don't believe in overloading the legislation with all manner of penalties, but on crucial things, in a limited and focused ways, we got to find to insert incentives for good behavior and compliance in the legislation. The last point is around funding. Yes, we get allocated money from the department. It has got its own challenges because often it's what remains of the department budget when it has allocated other functions. but so far we've not really reached a point where we are unable to function as a result of budget. But look, 27 staff, adding the intense and loan capacity, taking us to about 44, still way below what the task actually requires. And maybe I end there. I think the department may want to come in, and any of my colleagues may want to supplement my responses. Thank you for the opportunity.
Thank you, Mr. Matola. Any other contributions from the department before I hand over to the Deputy Minister? So I see Deputy Minister is still on the platform. Deputy Minister, are you available to give your concluding remarks?
Yes, Honorable Chance, I'm still here.
Please go ahead.
I think the bulk of the questions have been answered, and that's okay, save for the ones that have to do with concurrence from the presidency. We are following up with the presidency to see how far the president is with the matter related to the competition tribunal, and I think it's similar to what we reported yesterday with respect to the okay, I forget the name of the entity now, but the TRP executive director, where we need the concurrence of the National Treasury. And then on the matter that was raised by Honorable Chance with respect to the review process of PE legislation, the review is truly on the efficacy of the instruments we have been using in order to achieve what I now suppose is a commonly agreed search for outcomes. So I think on the outcomes front, even if rhetorically all of us in South Africa agree that there's a particular distributional outcome that we are hoping for, and that can only be achieved through accelerated economic growth, accelerated enterprise formation, and so on. And I think the B Commissioner made an important linkage between the design of the transformation fund and the pursuit of new enterprise formation and economic growth. So that BE is viewed not just as a form of rent seeking, as it tends to be portrayed, but is seen as more as a catalyzing policy instrument for new venture creation and wealth distribution as part of a robust economic growth setup. So that is broadly agreed. When will there's no panel appointed as yet, Honorable Chance, but the minister will update the committee. We won't proceed with that without having had a discussion with the committee on the process and how far it goes and what the scope of the review exercise will look like. Because in essence, it is a review of legislation that has been adopted by Parliament. So we have to then also be in conversation with Parliament when we undertake that work. And broadly speaking, I do want to then reemphasize the point that the Commissioner was making on both sides, for the tribunal and for the Commission, that the report under review is for the annual performance plans targets for the period under review, not the general mandate or the scope of work that these entities pursue. And to that extent, they will seem as though there's a narrow reporting framework on issues that should be broadly covered, but that's a function of what the instrument before us requires. We will, of course, Member Khoza, try to press the entities to improve on their performance where they are weaker on targets. And we will also try to encourage them to have almost periodic reports that reflect on the general state of affairs. If we take, for instance, the question on SOE compliance, we should be able to commission a standalone report, whether it looks for compliance over 5 years or over 10 years of SOEs with respect to BE legislation. But the sampling that was reported on relates to the targets that were adopted as part of the APP, that for this financial year, go and look at the performance of these entities. If we were to be looking at the performance of all SOEs, and we have about 704 entities classified as SOEs, it would require a much more elaborate auditing capability to fulfill it. And that would then have to fall outside the APP cycle, but be a report that we generate for helping both us in the executive and parliament to have a transversal picture of the state of compliance in the system as a whole. Otherwise, all the comments made, we take them, we will factor them into the work that we do, and how we guide the entities to improve both their planning and then performance reporting going forward. Overall, Honorable Chance, I will end there. Thank you very much.
Thank you, Deputy Minister. I see there are no more hands, but last chance for members if you wish to have any supplementaries. Andre, could you just anything else on the agenda for today?
Mr. Chance, there's no further items on the agenda. We included the business for this meeting.
Yes,
But
so we
just to
members need
remind
to know that we
members,
have a meeting.
yes,
We have a
I
meeting
want
at
to
1
speak to
o'clock.
that.
Is that right?
That's correct, Chair.
Okay, so members just remember that we have a meeting on the Island View Terminal at 1 o'clock. Separate link has been sent out for that. But I wish to thank the Deputy Minister and your team for your presentations this morning and answering the questions comprehensively. This meeting now is now adjourned.
Thank you.
Thank you.
Thank you. Thank you, Chair. Thank you, members. Thank you, Deputy Minister.
Recording stopped.
Chair.